फुलला जो श्वास आता तो पुन्हा ना लागणी. माणसाने माणसाशी माणसा समवागणी. हीच अमुची प्रार्थना न हेच अमुचे मागणी. माणसाने माणसाशी
मुंबई आणि गोंय उच्च न्यायालयाचे न्यायाधीश भौमनिस्त प्रकाश बाब नाईक, माचेर तशेंच ह्या सभागृहात आशिल्ले बाकीचे मानिस्त विद्यार्थी भावांनो आनी भयणांनो, सगळ्यांक तुमकां खूब मायेन आनी तितल्याच उपाट मोगान भरिल्लो माये मोगाचो येवकार दिता. सुमार 2 म्हयने फाटीं म्हजी पयलीच भेट भौमनिस्त न्यायाधीश प्रकाश बाब नायका लागीं जाल्ली. साऊथ गोवा एडवोकेट्स असोसिएशन हांणी एक कार्यक्रम घडून हाडिल्लो आनी ह्या कार्यक्रमाचें आमंत्रण घेवन आमी हायकोर्टांत गेल्ले. म्हजे सांगाता म्हजो कलीग एडवोकेट प्रसाद बाब नायकूय आशिल्लो. आमच्या मनांत असो एक गैरसमज जाल्लो आसा की पॉलिश्ड मेन हॅज टू स्पीक पॉलिश्ड इंग्लीश. ती एक ब्रँड इमेज अशी आसा की तूं पॉलिश जर दाखोवपाक सोदता जाल्यार तुवें पॉलिश्ड इंग्लिशेचो वापर करपाक जाय. लॉर्डशिपाक मेळून गेल्लो इंग्लीश पॉलिश आसपाकूच पडटाली अशी पॉलिश्ड इंग्लीश यूज करून वापर करून हांवें न्यायाधीशाक आमंत्रण दिलें. न्यायाधीशान हें आमंत्रण आयकून घेतलें, उठलो आनी मागीर म्हणूंक लागलो, हांव गोंयकार, मूळ गांव पेरणे आनी मागीर केपें. म्हज्या पॉलिश इंग्लिशीची जाप म्हाका पॉलिश कोंकणी भाशेन मेळ्ळी. अशें मानेस्ताक कोंकणी भास सोडून आनी खंयच्याय भाशेन येवकार दिवप योग्य जावचें ना. तुमच्या सगल्याच्या वतीन हांव आयच्या मानेस्ताक ह्या समयार खूब मोगान येवकार दिता. आमी ताचे उपकारी आनी ऋणकारी ते हांगा आयले, ताचो मोलादीक समय आमकां दिल्लो आसा. गोंयकाराचेर आनी गोंयचो प्रेम असोच तुमच्या काळजांत सदांच उरूं. देव बरें करूं.
Honorable Justice Prakash D. Naik, originally from village Ozrim, Pedle, was born in village Sange. Initial schooling was in Kare Government School. Thereafter, he completed his graduation in BA from St. Xavier's College, Mapsa, and did his LLB from Siddharth Law College, Mumbai, and LLM from Mumbai University. He was enrolled as an advocate of the rolls of Bar Council of Maharashtra and Goa on 21st July 1986. He joined the chambers of senior advocate Shirish Gupte and initially started his practice both in criminal and civil matters. Later on, he specialized in criminal matters. Besides his practice as a law professional, he was also engaged as a part-time professor in Jitendra Siddharth Law College, Mumbai, and was a visiting professor for LLM course in Bombay University, Mumbai. He was elevated as additional judge of the High Court of Judiciary at Bombay on 17th March 2016. On a final note, he is also a good orator and has full command and knowledge on criminal laws, and we are grateful for his presence amongst us today. Ladies and gentlemen, it is my privilege to present before you Honorable Justice Prakash Naik.
Mr. Prasad Naik has said I am a good orator and I have a mastery over criminal laws. I don't think so. But I would make an attempt to express my view with little experience which I had as a criminal lawyer and as a judge while dealing with the matters, criminal matters. I would never consider myself to be an expert in criminal law or any other law. The law is such a thing that you can never master it in a day or in years together. You keep on learning. And I keep on learning it, as I've said, always say, from the lawyers who appraise me and who update me about the day-to-day changes in law, new laws, interpretation of law, judicial precedents. And on that basis, I develop my knowledge of law. As a student of law, it's a challenge before you to master the profession of lawyer. I recollect during my days, this legal profession was not given any importance because people used to think that it's not rewarding. I recollect those days when I had no telephone in my house and I used to go on a public telephone booth. It's a small illustration to give you to how the law has changed now, how the people's approach towards legal profession has changed. And the owner of the telephone booth could understand that I used to talk to some of my clients on the public telephone. And one day he asked me, तुम्हाला काय मिळतंय का? That means, do you get anything in this profession? So this is what the impression of the members of public with regards to the legal profession. It was indeed true to some extent. When I was studying law, most of my colleagues who were studying are employed in some concerns, some private concern, banks or government institutions, etc., etc. And law was being studied as a part-time studies. But now I could see at this introduction of 5 years law course and even for 3-year law course, all those students who are serious in this profession are joining law. And the dimension of legal profession has completely changed now. There are several ventures, avenues open to the lawyers. And considering this fact, it's a challenge before you to develop yourself as a thorough professional, as a lawyer. Whether you practice in criminal law or whether you practice in civil law, you have to master this profession. And for that, you have to keep certain factors in mind as to how you are going to master this profession. Life is a canvas. You are a masterpiece. You have to draw your life by developing yourself as a good citizen, as an able citizen, as an able lawyer when you practice law. Today you are students, tomorrow you are going to be the lawyers. So to be a lawyer, what is required to be done? You have to start right from inception, right from now when you are a student. At least now we have moot courts. We have no moot courts. I don't recollect having visited any court when I was a lawyer, when I was a student of law. Now, the practical experience is given by participating in moot courts. The students I find are very serious in their studies. Even I have been attending as a guest in moot court competition in various law colleges. I find that the performance of the students is par excellence. They study the law, they prepare themselves very well, they argue, they prepare as a lawyer before the moot court. They make research in on legal judicial precedents and present themselves before the court. Because presentation is one of the factors which you have to develop when you become a lawyer. Public speaking skills are required to be developed, for which you are required to be a voracious reader of all the subjects, not only law, not only IPC, CRPC, evidence, CPC, etc. You have to read. You have to read all the subjects, whether it's politics, whether it's science, whether it's medical science, medical jurisprudence, or any other topics. You have to be. You can face any challenge to contest any type of matter when you practice law. You should understand your strength. You have a strength. You should understand, and you should develop your strength. You know that hummingbird, small bird, it's a very small, tiny bird. The number of times it flicks its wings, that shows a strength. The ostrich has a strength in his legs. Likewise, you should understand your strength. You know the story of David and Goliath. One was a giant and one was a small, but the smaller one succeeded. This is what you should adopt yourself when you become a lawyer. This is on the motivational aspect as for you how you should start and look at your profession right from today. Now the topic of today's discussion is aspects of criminal law. You can be a criminal lawyer, you can be a master in criminal defense lawyer, you can be a prosecutor, you can be a civil lawyer. When I started my profession for a few years, a couple of years, I practiced in several courts. But then it so happened that I joined a lawyer, a senior, who was exclusively practicing criminal side, And after a few years, I found that nobody used to approach me for civil matters. And I started getting criminal matters. And then I developed myself, tried to develop myself as a criminal lawyer. So as a criminal lawyer, you should study in depth the criminal law. If you want to master the profession in criminal side, you have to study in depth the criminal law. What is crime ultimately? Crime is violation of public laws. Crime is punishable under the penal laws. According to Blackstone, the crime is violation of public duty. A person who is required to follow his public duty is committing violation of that which is punishable under the law. While studying criminal law, you should also understand what is criminology. Crime and criminology are two aspects which you must know. Criminology is a study of crime, a criminal, behavior of the criminal, the causes of crime, these theories of punishment, these theories of the schools of criminology. In crime, there are various elements of crime which you have to in-depth understand what are the ingredients which would constitute a particular crime. There are stages of crime. What are the stages? Intention, preparation, attempt and accomplishment. A person would intend to commit a particular crime, then he would prepare himself to commit that crime, and then he would make an attempt, and the attempt, when he makes an attempt, it becomes an accomplishment. These are the stages. There are elements of crime. There is something called as actus reus. There is something called as mens rea, concurrence, conduct. There's the Latin maxim, actus rea non facit nisi mensit rea. Actus and reus means a conduct of a person. He would conduct, then accuse a person, offender would commit a particular act towards commission of crime. Actus and reus, conduct, behavior, commission, accomplishment. These are the elements of crime which are required to study. As a student of law, I think you must be having a subject of criminology also. Criminology is a subject, of course, you may think that when you practice law, you may not be it's not necessary to study, but it's not like that. When you argue a matter before the court of law, sometimes a question of punishment or penology is also involved. Victimology is involved, which you are going to study while you study the criminology. In criminology, there are theories of punishment. As I have said, criminology is a study of a criminal behavior, study of crime, why a person commits crime, and what punishment should be given to them. There are theories of punishment. Which are those theories of punishment? Retributive theory, the theory of reformative, deterrent theory, compensatory theory. These are the theories which would help you in understanding what sort of punishment, how much punishment should be given to a criminal. Now, law prescribes a maximum punishment and minimum punishment. What is retributive? Retributive was considered to be eye for an eye. That means if a person commits harm, commensurate with that harm, the person should be punished. Deterrence means to deter a person from committing a particular crime. That if a person is punished, if given a death penalty, the others would deter from committing the crime. It's for those other person who would be prevented from commission of crime. That is the effect of deterrent. So what do you mean by reformative? Reformative is where an opportunity should be given to a person to reform himself. It's not that every person is criminal by nature. Sometimes because of certain circumstances a person commits a crime, he must be given an opportunity to reform himself. That is reformative theory of punishment. Compensatory, to give compensation. That a person can be, who is a victim in that case, should be given compensation. And preventive theory of punishment, to stop him from commission of crime. A person should be stopped so that he would not commit crime in future. That's sentencing him to jail for imprisonment. Cancelling a license of a person who is committing the crime of rash and negligent driving. That means to prevent a particular. So these are the theories of punishment which should help you when you argue a matter before the court of law as to what punishment could be given. Because the reformative approach which is followed nowadays is one of the aspects which we consider. Even in death penalty, whenever a death penalty is involved, we think that whether a death penalty should be imposed against a person, because Supreme Court has now said time and again that capital punishment or a death penalty should be imposed in rarest of the rare cases. Therefore, some sort of reformative approach should be given. Of course, when a person is convicted for an offence under 302, that is murder, the maximum punishment is death and the minimum punishment is life imprisonment. There's a debate about capital punishment, whether it should be imposed, whether it should be abolished. Some countries have abolished the death penalty. The persons who support the abolition, their argument is that death penalty ultimately doesn't help. It has not decreased the commission of heinous crimes. So why death penalty? And there are some cases, the persons who support death penalty has argued, there are some sort of crime which are so heinous, the magnitude of such crime is required to be looked into, and the death penalty could be a only punishment to be provided to such person. Now Supreme Court in various decisions, like you see, those decisions like Machi Singh, Bachi Singh, then Nirbhaya murder case, then Shabnam's case, then that Manu Sharma's case, several other cases, the Supreme Court has now slowly laying down a guidelines to consider what is aggravating circumstances and what are the other circumstances, the motivating circumstances which have to be considered while imposing the death penalty. Aggravating means a person has committed a heinous crime, there is no chance of improvement, then death is the only punishment should be given to. But there are some other factors which are to be taken into consideration, for which the court may consider reducing the death penalty, not imposing death penalty, or if the death penalty is imposed, it should be reduced to life imprisonment. The study of criminology will help us in understanding all these factors. What are the causes of crime? People commit crime for various reasons. Poverty is one of the factors. Psychological factors one of the factors. Psychotic factors one of the factors. Economic factors. And the company, the bad company, and the various other factors which compel the person. There are certain disorders which compel the persons to commit the crime. So these causes of crime, as a student of law, we are required to understand, so that we will understand as to how to argue a matter before the court of law when you present yourself before the court. Now there are, in criminology, there are schools of criminology. The school called as demonological school, classical school, neoclassical school, positive school. This is relating to the causes of crime. Demonological, the person who commits a crime feels that there is some demon in between me, and for that reason he commits a crime. So neoclassical or classical school means it's a school which proposes that there should not be barbaric punishment. Neoclassical school thinks that propounds that the modern technology or modern view should be reformative approach should be followed, or scientific approach should be followed when you determine as to why a person committing crime and what sort of punishment should be given to him. Similarly, positive school of studies also they propounds that we must understand why a person commits crime. In criminology, you will find the study of some eminent persons like Lombroso, like Andrei Ferraco, like various other persons who have studied criminology, and they have published books and said as to why a person commits crime. For example, like Lombroso. Lombroso thought that we should have a scientific approach towards finding out why a person commits crime. According to him, by birth, some persons have that instincts, and the way the structure of his body, the structure of his nose, structure of his head, structure of his skull, all these would determine as to why a person commits crime. This is according to Lombroso. Then similarly, various others like Garofalo has said that these factors we should understand as to why a person is compelled to commit crime. Sometimes it may be because of economic factor, but there are some people like psychotic disorders, having psychotic disorder. Like in Bombay, we had an old case when I was not even a student of law. There was some person called as Raman Raghav. Now that Raman Raghav said that he is getting some orders from God, and he kept on committing crime. If you had been to Bombay, you will find there is some central line and western line railway line. He killed some persons who were hutman dwellers in a central line and some persons from the hutman dwellers in a western line. And he went on killing them. He killed several persons. The police did not get clue as to who is committing the crime. Then one day they could nab this person who was actually a psychopath. And you must have seen some films also where serial killers are committing crime for no reason. So he was like that psychopath. And he was arrested and he confessed that I have committed murders because I was getting orders from the God. So there are such type of people who commit crime because they think that they are getting orders from the God and which compel them to commit crime. This is one case which was actually based on the law of insanity. As a student of law, you will find there is a chapter called as General Exceptions, and section 84 of IPC deals with law of insanity. What is law of insanity? The person who commits a crime did not understand what he was doing at the time of commission of crime and the consequences of his act. This is the law which is there under section 84. Margao took that defense in his trial, his lawyers of course, that he did not understand what he was doing at that point of time. Of course, in spite of that, on certain finer these aspects, the factual aspects of the matter, he was convicted for an offence under 302 and he was sentenced to death. But then it so happened he preferred an appeal, and the sentence of confirmation awarded by the Sessions Court is always required to be confirmed by the High Court. Unless it is confirmed by the High Court, the sentence cannot be executed. So he filed an appeal and there was a confirmation case also. At the time of confirmation case, the report was given to the court that he is in some delusions. Therefore, at the moment, the death penalty should not be imposed. The matter was kept in abeyance. But he was convicted on the basis that the court found that at certain stage, you could make out that he was understanding what he was doing. Therefore, he should have known the consequences of the act, that what he is doing will result in the death of the person. On that basis, he was convicted. Now, the law is there's a difference between legal insanity and medical insanity. What is medical insanity may not be legal insanity. Legal insanity, the case of that person should fall clearly under section 84 of the IPC, which is the general exception. And you all know, as far as general exceptions are concerned, the burden is on the accused, which shifts by section 105 of the Evidence Act. Similarly, there is one famous case, English case, which is called as McNaughton's case. There is something called as McNaughton rules. McNaughton is one person, or one such person, who killed the secretary of the Prime Minister. And his theory was that he wanted to kill Prime Minister Edmund, and under the belief that he is killing Prime Minister, he killed the secretary of Prime Minister. And he got some orders to commit this particular crime. This is, that psychopaths or psychological factor, or the person doesn't understand what he is doing or the consequences of his act. But here, the benefit was given to that person of the law of insanity. But there was a huge outcry in the society as to why such a person is given the benefit of law of insanity. And there was something called as the courts in the UK has formulated the rules as to determine as to when the law of insanity can be utilized. And those rules are called as McNaughton rules. So this is what you are required to understand. Suppose if you get a case of a person you are going to defend, such as psychopath or such a person, whether your case would fall under section 84 of the evidence, 84 of IPC. A criminal lawyer should understand the finer intricacies of criminal law. He should understand as to what are the ingredients which would constitute the offence. Indian Penal Code is a vast law. We are following this law. Macaulay has propounded this act, and since last so many years, subject to certain amendments which have been brought into force, we have been following this law. When you practice law, you should understand as to what defense you are supposed to take. Indian Penal Code consists of offences against body, offences against property, sexual offences, offences relating to marriage, defamation, cruelty, all sorts of offences. You should master all of them. You should understand what are the provisions of Criminal Procedure Code, what are the provisions of Indian Penal Code, what is Evidence Act. So criminal law or criminal lawyer should understand the Evidence Act, the Criminal Procedure Code, IPC, and there are various other laws also which also contains the penal provision. So unless you understand them and apply your mind in proper perspectives, it will be difficult for you to practice in a criminal court of law. So you should understand all these aspects too as to how to cross-examine. For example, as I have said in the last speech which I have delivered at Margao, the defense lawyer is required to know how to cross-examine the witness. It is always said that lawyers are jack of all trades. Not that they are master of none, jack of all trades. A lawyer is supposed to know everything. Lawyer gets any type of cases. Some clients of yours will come with you with a piece of paper and say that this is my case. It's your skill how to develop that paper, one page into 100 pages by filing some petition, etc., etc. For that, you are supposed to know the law. If you are a criminal law, it's a criminal matter, you are supposed to know criminal law. The Code of Criminal Procedure contains various provisions related to investigation and rights of accused, etc., etc. If you are a defense lawyer, you should know what are the rights of the accused, which you will find under the Constitution as well as under the Code of Criminal Procedure. What are the basic rights of the accused? Now, a person who has committed a cognizable offence can be arrested without warrant. That you will find in section 41 of the Code of Criminal Procedure. Now section 41A, 41B, 41C, 41D, 46, 47, section 50, 57, all these sections are relating to the rights of the accused. Now there is a decision of the Supreme Court in the case of Arnesh Kumar, where the Supreme Court has said that a notice is required to be given to the accused before he is arrested if the offence is punishable up to 7 years. So if he is arrested, he should be informed grounds of arrest. He should be informed why he is arrested. It should be recorded why he is arrested. He should be given an opportunity of engage his lawyer. He should be given an opportunity to engage his lawyer when he is interrogated by the police to some extent. He should be produced before the court of law within 24 hours. If he complains against the police, he should be taken for medical examination before the medical officer. All these provisions you have to know when a client approaches you, when he is arrested, when he is produced before the court of law for remand. Similar rights you will find in Constitution. Article 20, Article 22 are the two basic provisions which contains the rights of the accused. It deals with the right to inform about the grounds of arrest. The person cannot be punished for more than the punishment provided for that offence at the time of commission of offence. Person cannot be compelled to speak against him or to be witness against himself. He cannot be compelled to give incriminating evidence against himself. He should be produced before the court of law within 24 hours. He has a right to defend himself. All this you will find under Article 20 and Article 22. And the most important which we find is Article 21 of the Constitution of India. No person should be deprived of his life and liberty without due process of law. Now Supreme Court time and again has enlarged the scope of Article 21. As to what do we mean by Article 21? What is the scope of Article 20? It has been applied to various cases. Even to environmental issues, Article 21 has been applied. And more particularly in criminal law, we will find Article 21 is the pivotal provision which protects the right of the person who is deprived of his liberty. Now, what do you mean by deprived of his liberty without due process of law? Otherwise, everybody would argue that arrest of a person is also depriving him of his liberty. That's not so. Without due process of law means if there is a provision of law, by following the due process of law, by following the process of law, a person can be arrested. Then, of course, it amounts to depriving liberty, but by following due process of law. Which has been considered by the courts as one of the important factors which would violate the right of the accused if he is arrested without following due process of law. Therefore, without any offence being registered, person is arrested, it violates the Article 21. Without following the procedural aspects of the law embodied under the CRPC, it would violate Article 21. Long incarceration in custody without trial violates Article 21 of law. Now, Supreme Court recently in various decisions has said time and again that if you can't give trial, a person is in custody, then at least grant him bail. Whatever may be the offence, but long incarceration, a person is entitled for trial. If you can't conduct a trial, then at least grant him bail. Therefore, it amounts to violation of the right of the liberty, violation of liberty under Article 21 of the Constitution of India. There are various decisions of the Supreme Court as to even if there are embargoes in granting bail to a person, it would override if there is a violation of Article 21. That a person has, I had come across one case where the person was in custody for 12 years. And not a single witness was examined before the court of law. Of course, there are various factors why the trials are not going on. We can't blame anybody. Because somewhere in between, because of COVID-19 also for 2 years, there was backlog of various cases, as a result of which the trials could not be. But one case which I came across, that 12 years person was in custody, but he was arrested in a case under MCOC. Of course, in Goa that law is not that. In Maharashtra that law. Maharashtra Organized Crime Commission, Prevention of Organized Crime Criminals Act. And there is an embargo under that provision as to under Section 21 as to bail should not be granted to that person unless hearing is given to the public prosecutor and that there is reasonable belief to come to the conclusion that he has not committed an offence. This is the embargo. In spite of that, considering various decisions of the Supreme Court, I said that 12 years is a long incarceration. A person is innocent till he is proved guilty. Of course, the courts are required to strike a balance between the rights of the victims, the impact of the crime committed by a person, and also considering the fact that how long a person accused is in custody. So these factors are required to be considered as to whether a person can be granted in spite of rigors for granting bail. This amounts to violation of Article 21. The student of law should study Article 21. Even if you are a criminal lawyer, you master that constitutional law. Constitutional law is a parent act. All the laws flow from Constitution. Any act, any law brought into force which is ultra virus of Constitution can be struck down. You all know about it. So master Constitution and then master all the laws. Join some senior lawyer, try to study law, watch at him how he argues the cases. As I've said last time, nowadays the lawyers want to start practicing right from the day one. They will go into the court and say that I am capable of arguing. That's not so. It's not so easy. The gestation period in this profession is little long. You have to study it step by step. Once you master that, join some senior, understand drafting. Drafting is the factor which is neglected by all the lawyers. Drafting in trial court, drafting in the high court, there is vast distinction between drafting. You should know how to draft complaint. You should know how to draft writ petitions, revision applications, appeals. If you practice in high court, you should know how to draft all these writ petitions, criminal writ petitions, appeals under which provision, appeals for how that you should know the law. You should know the provisions of criminal procedure code. You should know the law of limitation. This I am telling you because tomorrow you are going to be lawyers. Today students of law will be lawyers tomorrow. Therefore you should right from the day one, start from today, that you are going to understand what you are studying today, have a practical approach as to how you are going to apply it. As a student of law, we study law, but ultimately it's a practical experience which we get in the courts of law, which would take you to the higher position. Therefore, unless you expertise yourself in all these aspects, it will be difficult for you because now the profession has been there is a lot of competition in this profession. You are a professional means you are required or expected to deliver before the court of law and to defend your client before the court of law. And how you defend your client before the court of law? When you know the law. And how you know the law? When you read the law. Understand it. Understand the scope, how to interpret the law. Understand the basic principles of law of evidence. The cardinal principle of criminal jurisprudence is that the prosecution has to prove the case beyond all reasonable doubt. The benefit of doubt, if any, always goes to that. You know that, and you should know that. So it's a duty of the prosecution to prove the case beyond reasonable doubt. As a lawyer, you are supposed to know this, and you are supposed to know the evidence principles. What is proof? What is burden of proof? What is evidence? What is admissible evidence? What is the confessions? What are extrajudicial confessions? Confession before the court of law. Statement of the accused before the court of law, whether the statement is admissible in evidence. Why it is not admissible in evidence. What is the effect of section 25, 26 and 27 of the Evidence Act? What is discovery under the Evidence Act? What is the effect of statement made by the accused before the police while he is in custody? Whether it amounts to confession, whether it is sufficient to prove the guilt against him. All this you have to learn. And for that you have to study. You have to read the provisions of law. As I have said, unless you read and understand and interpret, it will be difficult for you to sustain the profession. But commitment, hard work, of course, is going to take you to the best position in life as a lawyer. So these provision you must master. Like for example, a person is arrested. He will be produced before the court of law. Your work starts from that time. You will appear for him as a lawyer. Now the procedure is, he will be produced before the court of law. He will be remanded to custody. You should know whether he is produced before the court of law within the time limit. What is that time limit? 24 hours from the time of arrest. Whether the grounds of arrest are informed to him. For what offence he has been arrested. Whether it's a bailable offence, non-bailable offence, cognizable offence, non-cognizable offence. What are these bailable, non-bailable, cognizable, non-cognizable? The common man feels that bailable means bail can be granted. Non-bailable means lifetime bail cannot be granted. That's not so. Non-bailable doesn't mean that no bail should be granted. Non-bailable means if a case is made out, a court can grant bail. Therefore, when you appear before the court of law, you should know all these factors. How long a person can be remanded? There is a limitation for remanding a person to police custody. Beyond 15 days, he can't be remanded for police custody. So whether he can be remanded beyond 15 days, on what grounds can be remanded to custody, what is the job of the learned magistrate before whom he is produced, what order the magistrate is required to pass, what is judicial custody, what is police custody. This you may not find in CRPC, but this you will have to come across when you appear before the court of law, when you are going to pass out law and become a lawyer. But the foundation you have to study now. For that, don't study just to pass the examination of your law. Study with a view that you have to master that law. Study with a view that you have to interpret the provisions of law. Go to the court and see how the lawyers argue before the court of law. They will convince the court that what is wrong is what is right. What is wrong is right, that is the lawyer tries to convince the court. The lawyer convinces the court that don't give him 10 years imprisonment, give him 5 years imprisonment. That penology, principle of penology would come into force, theories of punishment would come into force. Therefore, you should understand this. That the circumstances in which he committed crime. Why you should not be sentenced to life imprisonment? Why you should be sentenced only to 2 years? Why you should be released on probation? Why a lesser punishment should be given to him? Why a reformative approach should be there, should be adopted? These are the skills of lawyers. And they argue before us and sometimes convince us. Sometimes they are emotional, sometimes they are aggressive. Sometimes they, that bowl that googly, and see that the court is, compelled to believe what they are saying. And this is a skill of law. I was also once upon a time a lawyer, and now I am on the other side, but I was also a lawyer. I understand how to the lawyers argue their cases, and they always, of course, it is their right to defend their client, and they are rightly doing so. But when you become a lawyer, you should also keep in mind one thing, that professional ethics you should keep in mind. Overnight money, easy money, immediate money. You don't want to buy Mercedes immediately within 2 years of your practice. Don't go for that. Take time, develop yourself. And when you slowly develop yourself and become an able lawyer, then there is no end for earning in this profession. And this profession, till you are hale and hearty, you can practice profession. There is no age bar. But go step by step. So coming back to when a person is produced before the court of law, you should understand what are these factors, what are the procedural law to defend your client. So that's why I said a bailable, non-bailable, then remand. There are several cases as to how long a person can be remanded to custody. That Anupam Kulkarni's case, we say that it can't be more than 15 days. There are cases on the arrest of a person, the Joginder Kumar's case, which deals with the arrest of a person. There are cases about the notice under 41A to be given to the accused, that is that Arnesh Kumar's case. There is a case of DK Basu, which says that the accused should be informed of his right to engage lawyer of his choice, grounds of arrest. There are several such decisions which you should know. There is the right of bail to the accused. As I have said, bailable, non-bailable. The bailable, the bail can be granted easily. Section 436 of CRPC deals with bailable offences. 438 deals with pre-arrest bail, anticipated bail. 439 and 436 deals with 439 deals with grant of bail by Session Court and High Court, which the magistrate doesn't have power. There is a default bail under Section 167(2) of CRPC, which you must take chance that you are required to file an application for default bail. All this aspect you must know as to what is default bail, because you have to, as a lawyer, you will have to file an application immediately seeking that bail for default, because once the charge sheet is filed, the bail cannot be done. So how the investigation proceeds? See, the FIR is registered under 154. Then a person is arrested or not arrested. If he is arrested, he will be remanded. After the police remand is over, judicial custody will be granted. After the judicial custody is over, then the police might file a charge sheet. There is a limitation prescribed for filing charge sheet, 60 days or 90 days, depending upon the punishment provided under the law. If the charge sheet is not filed within 60 days or 90 days, as per the offence which is charged against him, application can be filed under 167(2) for bail, which is called as default bail. The charge sheet is filed under Section 173. Further investigation can be conducted under 173(8). And then the case is put up before the court of law. Charge sheet is filed before the court of law. Then the case is either triable by the magistrate, it is either triable by the session court. So depending upon the nature of offence committed, the offence which is committed under the IPC, there is one schedule provided under the CRPC where you will get all these details, whether the offence is bailable, non-bailable, cognizable, non-cognizable, triable by which court. Therefore, offence of 302 is triable by the sessions court. Then it is required to be committed to the court of session. Then it will be triable before the session court. Then the trial would start. And your job as a criminal lawyer would start from there, when you appear before the court of law. What defense you should lay to defend your client, that you have to think right from inception. How you would cross-examine the witnesses. There your skill of cross-examine, applying logic. I don't know whether logic is a subject for law. It's not there. But when I was a student, not in law, but a student of arts, we had one subject of logic, and that time we thought it is useless. But now I think it was necessary. Like that, all logical questions are there. All crows are black. A is a crow, therefore he is black. Like that instantly. That why a person has died. Is it because of this bullet injury? Is it because of this firearm? Whether this firearm was used in commission of crime? What is the distance between the person who has fired and the deceased? Is it possible that a person who died because of that firing? What is the cause of death? What is the cause of death mentioned in the post-mortem report? What questions to be asked to the medical officer? What questions to be asked to the handwriting expert? That's why I said that the lawyer is jack of all trades. He's not a handwriting expert. He's not a medical officer. But he would cross-examine effectively that medical officer and bring home his point that what the medical officer is saying is not correct. Who is an expert here? Medical officer. But the lawyer is expert of expert. This is where your skill is required. You should join this profession. Nowadays, unfortunately, we find that all these students who basically studied in national or universities, they don't join profession. They join some multinational companies, and maybe because they are paid well, got flat packages. But the challenge is in the legal profession. The challenge is when you practice in the court of law. And everyone must practice in the court of law. I remember when I passed out, only 2 of us from my class had joined the profession. Because I said that during those days, most of the time, most of the students were joining law because of that job opportunity, etc., etc. But now that's not so. Be serious about it. And apply your mind right from inception. From now onwards, you think how you are going to develop yourself as a lawyer. Apart from the CRPC and IPC, as I have said, you should also learn the Evidence Act, which is the most difficult. Even today, I find it difficult to understand some of the provisions of Evidence Act. According to me, the Evidence Act is the most difficult act which we are having in our country. What is proof? What is disproved? What is admissible? What is not admissible? The general public says that he has admitted a commission of murder, then how is acquitted by the court? That is the general perception, not a lawyer's perception. Lawyer would know that the statement made by him before the police is not admissible in evidence. It is hit by section 26 of the Evidence Act. Otherwise, what would have happened? That any person makes a statement, confesses the crime, the police would have compelled him to confess the crime, and in all cases would have resulted in acquittal, although that person is innocent. Therefore, under 102 of the Evidence Act, the duty is cast upon the prosecution, which sometimes shift upon the you in 105 when you take, for example, the defense which are there in this general exception. Otherwise, it is always their duty to prove the case beyond reasonable doubt. So that you must know that what is the defense, how you defend, what are these principles of Evidence Act. Documentary evidence, what is oral evidence, what is documentary evidence, primary evidence, secondary evidence. Read and apply it practically. What is recovery? What is discovery? How it is proved in the court of law, how the documents are marked as exhibits in the court of law. Where to stop cross-examination. Last time also I have said that you go on cross-examining and go on damaging your case. A lawyer should know where to stop. A lawyer should be a good listener. Lawyer should have a patience. Lawyer can be sometimes aggressive, but most of the time the lawyer should be submissive. Sometimes the aggression comes because you find that your client is being he is innocent or he is being actually the victimized somebody, and the court is not with you on a particular point. But you have to strike a balance between being submissive and aggressive. To that extent, aggression you can keep. Otherwise, it's not necessary to be submissive. You see that how you would convince the court to bring home the point which you are going to argue before the court. Convince the court. Don't antagonize the court. Convince him as to how you are right. And as I said, it will all depend. If you master the law, you will be in a position to argue before the court. If you know the law, if you know the latest provisions of law, the decisions of law, If you know the ratio of the decisions, if you know the recent decision delivered by the courts of High Court or Supreme Court, you should know the judicial precedent, what is the effect of judicial precedent, binding effect of judicial precedent. How to interpret the provisions of law. What do you mean by harmonious construction? What could be the meaning of a law? You have to see the preamble of that law, act, to understand what could be the meaning which has been assigned to that particular provision in the law if you want to argue for it. So criminal law, criminology, penology, victimology are all these aspects you have to keep in mind. And you have to be, as I have said, work hard. You have to work hard. There is no substitute for hard work. And do it right from inception now. And for that, read your law. Read books of law. Read other books. Public speaking. Develop yourself as a public speaker. Stand in front of a mirror if you are getting scared of talking. Read the newspaper and find out what changes it would make in you. Develop your vocabulary. Your vocabulary can be developed only by reading. New words you have to find out. What are the new words? Go to the dictionary. Even if you read newspapers, English newspaper, if you want to develop it, you will find out various new words, articles in the newspapers. Read magazines. Your thought process would develop when you have thoughts in your mind. And the thoughts in your mind will be there if your vocabulary is strong. You have various words in your mind. And that will help you in convincing the court and arguing the court case before the court of law. As I said, public speaking is one of the factors which the lawyers will have to keep in mind, will have to develop. So all these students who are here, I was also one of the students. I still continue to be a student. As I have said, I keep on learning and you should also keep on learning. You should never say that I know everything. There is no person in this world who knows everything. There is no lawyer in this world who knows everything. There is no judge in this world who can say that I know everything about the law. We should keep on learning. I keep on learning, as I said, from the lawyers who argue for me. I keep on learning from the members of public. I think I have taken much of years, and the talk should not get boring, and one should stop at a particular stage before the people want you to stop. So I think I got this great opportunity to be amongst the students in expressing some concepts of law which I understand, and it's a great pleasure that because I have been here as a visiting judge in Goa, I could get this opportunity to express my views amongst yourself. In fact, it was in back of my mind all these years after I was elevated that one day I should be in Goa so that I would be amongst the lawyers in Goa, the court in Goa where I am born, and the opportunity to share my views with the students, which is the greatest thing. I thank you all for giving this opportunity. So if anybody wants to interact anything, you are welcome.
So we are told we have to study, but now you tell us we have to learn. Where is the anomaly and where do we cut the line?
Studying and learning is one and the same thing. There can't be distinction between studying and learning. What I said is that your approach should be that tomorrow you are going to be the students who are studying law would be lawyers tomorrow, and that practical approach should be kept in mind. So as a students of law, you study books of law. Of course, the basic foundations here as to the basic elements of law are studied as a student. But when you become a lawyer, it's slightly different thing. These are to be implemented in practice. And practical lawyer would be performing good when he actually practicing the code of law, understanding how to interpret the provisions of law which you have studied as a student.
Sir, I wanted to know your opinion on how preventive detention law in our country is likely to be misused. You talked about rights of accused. How do you think the law of preventive detention has a bearing on that? Briefly, sir. Thank you.
See, Maharashtra will find that MPD, Prevention of Dangerous Activities of Slumdog Players Criminal Act. The basic idea of propounding this law is to prevent a person from committing crime. But to arrive at that subjective satisfaction that a person is required to be preventively detained from commission of crime, there has to be material for the detaining authority to formulate the grounds that he has committed so crimes. Several cases are registered against him. He is a dangerous person to the society. He is a person who is involved in smuggling, for example. There is some act like coffee process which deals with some smuggling also. There is an act called as PIT, which deals with prevention of illicit trafficking, narcotic drugs and psychotropic substances act. But for all these acts, preventive detention law, the common factor is there has to be a material before the detaining authority to come to the conclusion that if left free, this person is likely to commit similar offences in the future. If that subjective satisfaction is not there, and merely saying that he is likely to commit such similar offences in the future is not sufficient, there has to be actually a material. Otherwise, on that ground, the order of detention can be set aside. You will find that this order of detention are always required to be confirmed by the government. There is something called as advisory board. The advisory board confirms the orders or revokes the order of detention. If it is not confirmed or revoked, a writ under Article 226 can be filed before the High Court, a writ of habeas corpus, challenging the order of detention. And considering this aspect, like there is no material, there is non-application of mind, the violation of Article 22, Section 5, Article 22 and 25 of the Constitution of India, and all these grounds preventive detention orders can be set. Alright? In nutshell, I can tell you only this much.
Judges of the lower court are reluctant in giving bail with a fear of being targeted. So my question to your lordship is, till what extent does the public reaction act as a factor in matters like bail for the judges?
There are cases which are very heinous. There are cases which relate to violation of which are economic offences. The court, while granting bail, is required to consider several factors. It's not only lower court, it can be any court. The court is required to consider several factors, such as the nature of crime committed by a person, the magnitude of the crime, its effect upon the society, the punishment provided to the crime committed by the person, and the period for which the person is already in custody. These factors need to be considered while granting bail. Now there are Supreme Court judgments which say that long incarceration in custody is a ground for bail. The person is innocent, he is proved guilty. He can't be incarcerated in custody for indefinite period if the trial is not over. There are also judgments of the Supreme Court which say that for heinous crime you have to strike the balance between the period of custody and the nature of crime committed. Sometimes the minor offense is committed and the punishment suppose is say 3 years. The person is already in jail for 1 year. How long that person can be kept in custody? That is one. A series of crimes are committed by a person. Triple murder. Person is arrested, is produced before the magistrate. Magistrate can't grant bail because of legal restriction. Is produced before the state, applies for the session court. The session court may not grant the bail because the nature of crime committed by. The serial criminal commits serious offences. You know that case of Surendra Kohli, that's from Punjab, which is where it was said that several persons were killed, they were sexually abused, and that person ate the body of this person. That was sort of the case, like psychopath. Whether such person can be granted to a power control. Of course, the apex court has said that courts are reluctant to grant bail, lower courts are reluctant to grant bail. The court need to consider all this. I don't advise them to grant bail in every case. It depends on the factors, the case, the facts of the case which is there before the court. Otherwise, generally, all these are the principles which are to be taken into consideration as a court while granting bail. That is the decision of the Supreme Court in the case of Sanjay Chandra's case. There are various other decisions. Guru Bakshi's case, Guru Charan Singh's case, old laws. In the older days, it was said that the jail should be an exception and bail should be a rule. Can we say in the present context? There are some serious offences committed by us. Even juveniles are committing serious offences. Of course, they got benefit of that age below up to 18, below 18 years of age, they are considered. So there are some economic offences like the public money has been misutilized, misappropriation of public money. All those economic offences, fugitive offenders, there are cases pending. So all these cases depends as to what is the case, and these factors the court is required to consider while granting bail. We can't have a generalized principle that all persons should be granted bail by the lower court, or all applications should be rejected by the lower court. It depends on facts and circumstances of every case. But the court is required to strike a balance between custody and the regime. Yes? Yes? Double your party. Yes, yes.
Yeah. With what has happened during the course of the week with regards to news click and the UPA law and all this, how concerned should we be as citizens of this country? Because we clearly can see politicization of law, or law being used to sort of narrow down on things which may not be a concern. May also be a concern, but may not necessarily be a concern.
No, I didn't understand your question.
How concerned should we be?
How concerned should we be?
Because of what is happening. You just target someone, you go for them, you use the law, you make sure that they are silenced.
How you should be concerned, it's a matter which you should decide. The judge is not required to give his opinion on this.
Being on that honorable chair, on the judgment day, if you are in little doubt, what level of stress you experience and how do you manage that level of stress?
You are asking about me. Alright. But good question, your concern for us. You see, when I was a lawyer, I thought in one mind that my client is innocent. But now the things have changed. I have come to the other side. When I'm a judge, I have to look into both the aspects. I have to look at the right of the accused. I have to look at the right of the victim also. I must see whether the innocent person has been involved in this case, and I should also see that what effect the crime had on that victim. Now, sometimes the question arises that the judge also comes in a situation as 50-50. No? This could be this way or this could be that. And then we are guided by the precedents of law and the principles of criminal jurisprudence as to what should be an approach of the judge by dealing with such cases. As you said, if there is a doubt in the mind of the judge as to how much stress he undergoes. Indeed, he goes under stress because ultimately there is nobody around to take a decision. It's me or a judge who has to take a decision, and my decision will declare the fate of either party. Either the accused will be declared as convicted, or he will be acquitted. Or the victim would feel that I got justice because the accused has been punished. But then we go by our thought and the principle that if there is a doubt, and the benefit of doubt should go to the person who will be incarcerated in jail for a lifetime if it is a case of murder. or a substantial period of time if it is any other case, then the benefit of doubt is also always tilt towards the end. This is the way I keep my approach. Then, as a judge, we also apply our mind to the factors involved in the society. What is the nature of crime committed by a person? What are the circumstances in which he has committed a crime? Sometimes we apply those theories which I have said, that reformative approach. Sometimes we think that this is the case where you should have a deterrent approach, or we have a retributive approach, or an opportunity should be given to that person to improve himself. And considering all these factors, but without forgetting the fact that victim is also a person. You know, the criminal law is such that it is most of the time said that victim is ignored, and we are more concerned about the rights of the accused. But then the law is that if a person is punished, it's a serious offense, he will be in jail for a lifetime. He can be punished with death penalty, or he can be punished with any other punishment. Taking that factor in mind, then we apply that if there is slightest doubt, then although we feel that this is a crime committed against so-so person, this is so-so a crime, we always feel towards here.
So one last question. Do media reports impact judicial decision making?
The journalist are here. See, it is always said that something called as media trial. I would say that the judges are affected by media, because then you would say that by reading newspapers I must be delivering my decisions. But it is said by the common public that the medias nowadays are involved so much in publicizing the particular case or the offense committed by a person, or giving their decision before actually the trial tries him for that particular offense. And there is a lot of criticism also that the media can't go to such an extent. That's, we see that sometimes the witnesses are interviewed, and before going to the court, they give interview to the media. So it is said that it is having an effect. But as far as I am concerned, I would always go by the fact, and every judge should go by the fact, that what is the evidence before the court of law, what is adduced in evidence before the court of law, how the prosecution has proved the case before the court of law would depend upon the decision in this case, and it would not be influenced by the media, and the judges don't get influenced by the media. This is what happens.
Respected His Lordship, Honorable Shri Prakash S. Naik, respected Judge of the Bombay High Court at Goa, dignitaries on the days, off the days, students, ladies and gentlemen. Well, sir has eloquently delivered this kind of an address without the use of any paper. But sir, you need to pardon me on this, because I will have a list to basically call out here using the paper. So it gives me immense pleasure to be standing here to propose this vote of thanks. I would at the outset begin by thanking our esteemed chief guest and resourceful speaker for today's second address of the GRK-Judiciary talks, Honorable Shri Justice Prakash Naik, respected Judge of the High Court of Bombay at Goa. The perfect delivery of your empowering speech has really left lasting imprints on the ears of the listeners, especially the prompt manner in which you did justice to the topic, aspects of criminal law. Your Lordship, we are in awe with your smooth delivery of an eloquent address. As I have said before, without even using this paper or any document to read out the content. Thank you for having accepted our invitation to be present here today amongst our midst despite your busy schedule. We are very much humbled and privileged to host you in our small premises. I wholeheartedly thank you on behalf of our faculty, administrative staff, and students. Ever grateful to you, sir. I also wish to express my gratitude to Advocate Pritham Morais, the first Vice President of the Mandal and the Co-Chairman of the Governing Council. He is the one who has conceptualized this idea behind the judiciary talks. And due to this concept, the students and faculty can witness great judicial minds deliberating on many practical topics like we just did today. Indeed, it is a pleasure to hear all of them, which otherwise would have been a distant reality. Thank you once again for striving at excellence and ensuring that this institution reaches greater heights through your thought process. I would also like to thank the President of the South Goa Advocates Association, member of Governing Council of the college, and now a newly inducted member of the Board of Management, Advocate Prasad Naik. He is our very own alumnus who has always supported the institution in every manner possible. Thank you, sir, for your gracious presence here this morning. I would also like to acknowledge the President of PTA, Advocate Avdut Arsekar, President of GRK-CL Alumni Association, Advocate Sanjeet Desai, Member of the Governing Council, Advocate Amira Razak, President of the South Goa District Consumer Forum, Advocate Sanjay Chodankar, the members of the press, advocates of South Goa Bar Association, and all the alumni of this institution for having taken your time off. Being a working Saturday, it indeed gives me a great pleasure to see you all at this common platform. I hope, along with this institution, your never-ending support to our great cause will lead us to greater heights. I owe my gratefulness to you. Thank you, one and all. I would also like to acknowledge the actors behind the scene. Not really actors, but actresses behind the scene. Our faculty, who have worked tirelessly towards this day. This happens to be the last session of the GRK-Judiciary talks for this semester. I am sure that in the near future, with your persistent efforts, we can achieve many, many more milestones. Thank you for your untiring efforts. I also accord a warm thanksgiving to our system administrator, Mr. Akshay Chari, the multitasking staff. To all of you, I can only bow and say thank you. Last, but definitely not the least, our students. Present here are the undergraduate students of the first year of both the programs and of course the postgraduate students of this institution. Thank you very much, students, for having come here and made your presence felt by the various kinds of questions that you have posted here today. Which means, in a nutshell, that they were paying attention to the address which was delivered by His Lordship. Thank you. I also thank our council members who have always been there with us, for us, and worked along with us wherever and whenever we require them. I thank you wholeheartedly and am extremely overwhelmed by your presence here this morning. Once again, I thank each one of you individually. If due to inadvertence I have left any name not taken, I beg apologies, but I'm sure that your cooperation with us will definitely go a long, long way. Have a great weekend and a lovely day too. God bless you all. Thank you.